Hello, my name's Kira Murray, and this is my video essay for Law and Politics of the Family at Lakehead University. In this video essay, I will be examining the Supreme Court case of B versus Children's Aid Society. Okay, well, before we get into the legal proceedings, let's take a look at some facts to get a better understanding of what's happening. The case of B versus Children's Aid Society of Metropolitan, Toronto, is a Supreme Court case that occurred within Canada. This case is about a child named Sheena and her parents. Sheena was born prematurely on June 25, 1983 in Toronto, Ontario. Due to medical complications, Sheena was brought to Sick Kids Children's Hospital where she received various different medical treatments, which at the time her parents allowed for. Unfortunately, Sheena's hemoglobin levels dropped significantly, which was impacting her heart and heading down a dangerous path which Sheena might not return from, being a premature baby. The doctors recommended a blood transfusion in order to keep her heart going. The parents then rejected this as they were Jehovah's Witnesses, and according to the National Library of Medicine, they do not usually accept blood transfusions. Without the blood transfusions, Sheena's doctors deemed this would be fatal. Due to the severity of Sheena's medical complications, the doctors deemed it necessary to do the blood transfusion for her greater good. This resulted in them contacting Children's Aid Society, and they went to the Family Division of the Ontario Provincial Court and received temporary custody of Sheena for 72 hours. From there, it was then extended for another 21 days in order to let Sheena fully recover. After almost a month of the Children's Aid Society having temporary wardship over Sheena, her parents were then awarded back their custody. The parents were quite upset that Sheena had to go through this situation, and ultimately, this brings us to the case of B versus Children's Aid Society of Metropolitan, Toronto. Sheena's parents, Richard B. and Bina B., filed a motion against the Children's Aid Society in reasoning that their parental rights were infringed upon. They stated that their parental rights were infringed upon in the areas of their freedom of religion and their right to liberty. Now, let's get into the legal proceedings. So we're actually going to take a look at the end and work our way up. So, the ruling. Richard B. and Bina B. claimed their rights of freedom of religion and right to liberty were infringed upon due to the Child Welfare Act for the treatment of their infant, Sheena. The judge dismissed the parents' appeal. So now let's take a look at why. In the Ontario Child Welfare Act and the Child, Youth and Family Services Act, Section B states that if a child is in need of protection, if the child requires medical treatment to cure, prevent, or alleviate physical harm or suffering, and the child's parent or the person having the child does not provide or refuses or is unavailable or unable to consent to the treatment. So, although their child was in life-threatening need for medical care, the parents denied this treatment, thus resulting in Children's Aid Society being granted temporary custody. So the parents claim that Section 7 of the Charter of Rights and Freedoms was infringed upon. So this section is everyone has the right to life, liberty, and security of the person, and the right not to be deprived of, therefore except in accordance with the principles of fundamental justice. Despite the parents' attempt to claim their rights were infringed upon, there was a decision made to provide Sheena with the life-saving medical care in accordance with the principles of the fundamental justice, according to the judge. This is a quote from the Supreme Court case that we are speaking about. So, the common law has long recognized the power of the state to intervene to protect children whose lives are in jeopardy and to promote their well-being, basing such intervention on its parents patria. This means state's authority to protect the vulnerable. Jurisdiction. Although an individual may refuse any medical procedures upon their own person, it is quite another matter to speak on another person's behalf, especially when the individual can't speak. Parental duties are to be discharged according to the best interests of the child. Sheena's parents, the appellants, claim that she, the newborn, identified with their religion, Jehovah's Witness, just like them. The respondents counter-argued this, that Sheena, being a baby, has never expressed any agreement with this religion or any of sorts, this then being an impingement against Sheena's freedom of conscience. In the end, as previously mentioned, Sheena's parents' motions against the Children's Aid Society Metropolitan Toronto were dismissed. The importance of this case. So when it comes to parental rights, especially in terms of medical care of children, it is the legal assumption that parents will make the best and wisest choice for their child's well-being. The common law has long recognized that parents are in the best position to take care of their children and make all the decisions necessary to ensure their well-being. This is a quote from the case B versus Children's Aid Society Metropolitan Toronto, page 317. While a significant number of parents do make the best decisions for their children, some parents may choose to make decisions that are not in the best interest of the child, and even at some points infringes on the child's rights, which is seen in the attempted motions through this case, thus even going against professional medical advice. However, when a vulnerable person, whether that a child, elder, mentally or physically impaired individual, has an individual making their medical decisions for them, which could be a next of kin, it is important to note that medical professionals will assert their opinions and legally protect the vulnerable in the case of misinformation or life-altering decisions. References.